This is a video for my administrative law class. It might also be useful for my legislation and regulation class. And we're going to do a quick chapter overview about the standards of review and deference to agencies when we have judicial review of agency actions. So depending on how your casebook is set up, sometimes there's one chapter or two about judicial review of agency actions. And usually part of it is about scope of review, or what we really mean standards of review, and how much deference courts give to agency decisions, decision making. And then another part will be typically about the availability of judicial review. When do you get to challenge an agency decision in court? Now here, I'm just hitting the highlights of what to look for in the cases that we're going to cover, and what to watch for, or how to organize your thoughts or your notes when you're listening to lectures or reviewing flashcards or things like that. Some students may find it helpful to use this as sort of a quick and dirty review at the end of the chapter, or recap about what we covered, so that it ties things together in your mind. So first, we're going to be talking about the scope of review, and we have the Administrative Procedure Act and also some judge-made law about this area. So it's the 701 to 706 of the Administrative Procedure Act by statute allow for judicial review of agency actions, and then spell out some of the standards of review that should be used in different cases. And as you can imagine, there's a lot of unanswered questions left by the statute, and the courts have filled in the gap a little bit. So when we talk about the standards of review, the most common ones we're going to talk about are arbitrary and capricious, or substantial evidence, or de novo. And this essentially is how much the court gets to substitute its own judgment for the agencies, or how much they're supposed to take the agency's judgment at its word. In this chapter, we're going to talk about something you've probably heard of called Chevron Deference, and some related doctrines to Chevron, like Mead and Skidmore and Auer and so forth. But this is a body of law that was created by the US Supreme Court specifically for when agencies are interpreting their own statutes or interpreting their own regulations and so forth. So this is about deference for interpretation, as opposed to policy decisions that we might evaluate under a different, the previous point. We're also going to have a section of this unit about questions of law versus questions of fact when we come to judicial review of the agency actions, and the courts take a different approach if they're reviewing a question of law, so the agency's legal argument, versus the agency's fact-finding or factual determinations. And finally, we're going to have a discussion about the science, and because some of our safety agencies, public health and safety agencies, are science-based agencies that have scientifically based policy about everything from vaccines to pharmaceuticals, or what drugs get approved, pollution and toxic substances in the environment, safety standards for automobiles, and so forth. And so we're going to, pollution in the workplace, safety standards in the workplace, and air contamination in factories and so forth. And they rely heavily on science and scientific expertise. And the courts, when we get into court, we have a problem with judges, many of whom are not scientists, having to evaluate the agency's scientific determination, or the agency's reliance on scientific experts, and to deal with the problem that sometimes we actually have some scientific uncertainty. So what happens when scientists can differ, or scientists can only make projections or statistical guesses about things, or estimates, but we're not in the realm of scientific proof. We're in the realm of scientifically informed decisions or testing and things like that. So all of those are going to be issues in this unit that we cover, and watch for them as we go through the cases. And that concludes our short video.